All clear. Thank you for being here today. We're hearing our case 1CA CV170227 North Canyon versus Ireland. Each side will have 20 minutes to present their argument. Appellant, if you want to save any time for rebuttal, you may, but you'll have to keep track of the time yourself. We have the clock at the podium for that purpose. We are recording the argument today, and in a few days you'll be able to see yourselves on YouTube. So, because we're recording it, please identify your client and yourself when you begin so we can keep everything straight. We've read the briefs, we've read the record, we've conferenced this case at length, so we're pretty familiar with the law and the facts of your case. So when you begin your argument, just begin right where you want us to go. So, counsel, you may begin.
Presiding Judge Howe, Judge Jones, and Judge Morris, may it please the Court. My name is Austin Ballio, and I represent the appellant North Canyon Ranch Owners Association. I do intend to reserve 5 minutes for rebuttal. The association is requesting that the Court overturn the trial court's judgment against it and find that the association has an enforceable lien against Miss Allen's home that can be foreclosed. We're asking for that relief for two reasons. First, the association, in fact, had a viable lien against Miss Allen's property that was subject to foreclosure. And second, Pamela Allen failed to appropriately prove her affirmative defenses of bankruptcy and res judicata. Unfortunately, the trial court misapplied the law in those situations and found in her favor. First, the association had, in fact, two liens on this property. One arose by virtue of the Declaration of Covenants, Conditions, and Restrictions that was recorded back in 1986. The second lien, it's an independent lien from the contractual lien, was created by the legislature in Arizona Revised Statute Section 33-1807. Each lien is independent and separate from the other. They both have different requirements in order for the liens to arise.
Well, I understand your point that there are, there are two ways to execute on the lien, but there's really only one lien. If you sought to execute the lien under the CC&Rs, you can also execute under the statute, correct? Because you'd be doubly paid.
Well, Your Honor, so under the statutory lien, it's not ripe for foreclosure until the delinquency is older than a year or is more than $1,200 delinquent. Such a requirement is not imposed under the contract. As soon as the assessment lien arises, Section 3.7D of the Declaration states you can foreclose on it. Whether it's a month, $10, it doesn't matter. There's no.
But once it's paid, you're right, under the other procedure goes away.
Correct. Once the assessment lien has been satisfied under either scenario, the other lien would automatically be extinguished because you're getting paid on that.
What if it's not satisfied, counsel?
So,
what if you start out on the first process and it's unsuccessful for one reason or another? Do you get to then say, okay, King's X, we're going to start doing the other process and start over again because it wasn't satisfied under the first attempt?
Yes. They're independent rights that the association has, and if you are unsuccessful under one right, there's nothing to say that you're precluded from executing your rights under another lien.
And so if the homeowners association preserves the right to go under either methodology, they would have to follow either methodology, right?
Correct.
The rules of those methodologies.
Correct. And in this case, they did.
I'm sorry, they did?
Yes, Your Honor.
But the failure to follow the procedure in one or the other when it goof up or prevent the execution of the other one.
So
Correct.
highly precisely.
I was going to
Yeah.
say, we're so technical in our language.
They're not mutually exclusive. If you're pursuing one right, one lien, and do it correctly, even though you didn't do it correctly on another lien, they don't cancel each other out. And I'd like to point out under the contractual lien, the declaration doesn't say that the association can only foreclose on a perfected assessment lien. It just says once the assessment lien arises, you can foreclose on it. Now, there are
perfected matters here because if it wasn't perfected, you would agree it was extinguished in bankruptcy, right?
No, the perfection only it only preserves your priority as against other liens on the property. That's why you would record your lien so that junior lien holders don't supersede your lien.
So you're saying that you don't have to perfect the lien, you can leave it an unperfected lien, but not have it discharged the way all other unperfected debts are discharged in bankruptcy? I want to be real clear on that. Is that your position? So it doesn't fall into the same category of other unperfected liens?
Yeah, so under the bankruptcy code, under section 523 of the Title 11, it specifically states in subsection J that the discharge injunction does not affect a creditor's ability to foreclose on a lien if it retains a security interest in the real property that is the principal residence of the debtor. That's what happens here. The assessment lien was against the debtor's principal residence, and there was no evidence in the trial court to suggest that the lien was stripped from the property.
Well, as I understand it, and correct me if I have it incorrect, if you went to execute on the contractual lien under the CC laws, you'd have to provide proper notice of doing that, correct?
Provide proper notice to the homeowner
Yes.
that you're proceeding under the contract?
Yes.
Yes.
And if you didn't, then it would be an unperfected lien. And are you saying that unperfected liens still survive in bankruptcy? They can be discharged, or they are not discharged?
What I'm saying in this case, it doesn't matter whether or not.
Oh,
It does to us.
I
Sure.
understand that.
Yeah.
But what I'm saying is that if you didn't, to get back to my goofing comment,
Right.
if you goofed up and didn't follow the proper procedure under the contractual provision, is an unperfected lien, and that can be discharged in bankruptcy. I understand that's not what you said the facts are, but assuming those are the facts.
Yeah, so the contractual lien is secured by the property by virtue of the contract, by the declaration. Because that's a secured lien, there has to be some action in the bankruptcy to strip that lien. There was no action in this case to strip the lien. The only evidence in the case was that Ms. Allen testified that she listed the association as an unsecured creditor, and her petition, which was admitted, shows that we were listed as an unsecured creditor. And the only other testimony was that no proof of claim was filed. However, that's insufficient in and of itself to find that the contractual lien was stripped from the property. Under the bankruptcy code, 11 U.S.C. section 506D specifically talks about secured status, and it's often referred to as the lien stripping statute. And it states that
To the extent that a lien secures a claim against the debtor that is not an allowed secured claim, such lien is void.
unless, if you look at subsection 2, such claim is not an allowed secured claim due only to the failure of an entity to file a proof of claim. And that's what they're asserting here is no proof of claim was filed, thus the court has to conclude that the lien was stripped. And under the 506D subsection 2, the court's saying no, that's not a valid reason to strip the lien. In addition, the Ninth Circuit Bankruptcy Appellate Panel in the In re Concannon case, which is 338 BR 90 on page 95, they say that lien stripping is actually not allowed in a Chapter 7 bankruptcy. And that's been the case since the U.S. Supreme Court decided the Do Snub
Again, I'm
case.
sorry.
The site is 338 BR 90, and it's on page 95.
Did you cite that in your briefing?
No, we did not, Your Honor.
And have you notified counsel of the citation?
No, I found it while I was preparing my arguments.
And we appreciate it if you filed a notice of supplemental authority.
I'm sorry.
Yeah, I appreciate it if you filed a notice of supplemental authority.
Will do.
Thank you.
Let me ask you, and it may be too factually intense, and you'll let me know if it's not supported by the record. The 1807 provisions have safeguards designed to protect homeowners, similar to some of the provisions in your CC&Rs. Yeah, I think that's not really in dispute. One of them is the notice provision, and I can't remember which subsection of 1807 it is. So your CC&Rs enacted before 1807 said you have to provide individual, basically, liens with notice of the exact amounts due. And the 1807 said, we're going to bypass that, or at least that's how I'm reading it. But you have to provide notice within 10 days when they ask for that information about how much is owed. It seems like the record supports the idea that Miss Allen asked you guys how much, and you guys sent her a statement that says zero due and owing. Why isn't that defeat your lien at this point? So you didn't do the CC&R. Well, maybe you did the CC&Rs or not, but under the statutory lien, if you told her she doesn't owe any money, why isn't that dispositive?
So first, the requirement of sending notice and allowing the debtor to respond within 10 days, that's a procedure in order to perfect the lien by filing a notice of claim of lien, which in our supplemental briefing we indicated that we did file a notice of claim of lien. The court can take judicial notice of that fact. It just wasn't presented in the trial court because no one was contesting priority. Now, as to the statutory lien, the statements that were sent to Ms. Allen, although they showed, and these were statements sent post-petition, so again, the association is enjoined from collecting personally from Ms. Allen, so we can't put on the statement, hey, by the way, we're still seeking to collect money from you personally on these pre-petition amounts. So the post-petition statements reflected what was currently owed after her bankruptcy. However, there was a provision that said, and put her on notice, this may not reflect all charges on your account. If there are attorney's fees and other fees on your account, you need to contact the office. And the testimony in trial was that she never availed herself of that. She read it, but did never call to say, hey, are there additional charges on my account?
Okay, so you excuse me. Okay, so the homeowners association sends her you're clear, no debts. The homeowners association CC&R say that you're going to give her notice of any claim of lien, right?
Correct.
And then, having told her that she doesn't owe anything and not having her get any lien notice under the CC&Rs, you then assert that it was her responsibility to contact the homeowners association to be sure she didn't owe them anything?
So she didn't have a personal obligation to pay those amounts because of the discharge injunction. However, the discharge injunction didn't affect the association's lien rights to foreclose on the property.
Against what she didn't owe?
Against what the bankruptcy injunction prevented the association from collecting from her personally.
So the notice essentially said, it looks like you don't owe anything, but you need to check with us to make sure?
That's essentially what the statements say.
Then what kind of notice is that then?
Well, she knew that her property had been in bankruptcy and that there were some attorney's fees and things that had been collected on the account. So there was an awareness of previous charges.
But she got a letter from NQA saying you're all clear. I'm confused if the letter says you're all clear, but I guess in fine print it says, but we don't know for sure, so be sure to call us.
So, I mean, and these arguments go towards whether or not the association waived its right to pursue a lien foreclosure by sending that type of an invoice. And again, the association's not intentionally relinquishing its lien rights by sending a debtor a statement saying at post-petition you don't owe any assessments, because it's prevented from doing so under the bankruptcy injunction. The discharge specifically states you can't go after the personal liability of the debtor. So you're tying the association's hands by saying, by not asserting, oh, by the way, we also have a lien on your property that's valued as X and we might foreclose on it in every statement, that they're intentionally waiving that right. And that's not fair for the association.
But you don't think that's a little misleading? You don't owe us anything, but you might?
I mean,
You don't owe us anything, but we're going to come after you for it?
they're doing the best they can to
They got
abide by the law.
They're the bosses. They're making the money.
But they actually did file a separate, and you've attached that to your supplemental pleading or your supplemental brief. They filed a separate notice saying, you are
Yes,
in arrears.
and I have so it was recorded on March 26th of 2012 in the Maricopa County Recorder's Office, number 2012-0248-786. So the document is out there. Everyone has notice of it. We just didn't admit it into the trial court because we didn't feel it was necessary to pursue our statutory lien rights, and no one was contesting our priority of our lien.
She never below argued that you guys had not properly recorded.
Correct.
Anyway.
That never came up. And under the statute says that it's automatically perfected as of the date the CC&Rs were recorded, which goes back to 1986, and that no additional recording has to be made. So even if the court decides, okay, you made a blunder or there wasn't sufficient evidence in the trial court to pursue their contractual lien, the association still has a right to pursue its statutory lien.
What about the idea that, yes, you have the statutory lien, but you decided to increase your burden by adding requirements under the CC&Rs? I know that you say that they're two separate liens, but they're practically the same lien.
So I'm going to answer your question, but I'd like to reserve my remaining time for appeal or for rebuttal. One of the biggest differences between the liens is the statute of limitations. The contract has a 6-year statute of limitations on the debt. So the association has a 6-year window and can go back 6 years to enforce a foreclosure of whatever amounts had been accrued on that lien for 6 years. The ARS 33-1807 has a 3-year statute of repose. So if that lien arises and after 3 years you don't enforce it, it extinguishes. So that's a huge difference, a 3 years difference between what can accrue that you can enforce. So many times associations in the industry will abide by their CC&R provisions and the statute, so they preserve both rights in case they have a greater opportunity to pursue maybe a 6-year window, or perhaps they want to pursue just a 3-year window.
So they don't conflict.
They don't conflict.
So in fact, 33-1807 and the CC&Rs can be read together.
Correct. And that's the position we stated in our supplemental brief.
When you say you read them together, are you saying that you've accepted the additional obligation to comply with the CC&Rs?
We're saying that they're not mutually exclusive, but they're not at war with each other. You can comply with one or the other without losing your right under one or the other.
And choosing to proceed under 1807 does not incorporate the CC&R provisions.
Correct.
Except that you're saying you're keeping them alive at the same time. I don't understand that.
Because they're two different remedies, two different enforcement abilities, and
because
why
the
preclude
statute-
yourself from a remedy when you can keep it alive?
Save your time.
Thanks.
Thank you, counsel. Counsel?
Good morning, gentlemen. I'm Dennis Brookshire, representing the defendant, appellee in this matter, Pamela Allen. There are multiple grounds to affirm the trial court's decision and ruling finding that the homeowners association failed to meet its burden of proof. That's the ultimate conclusion reached by Judge Udall. Regarding the issues relative to the application of the CC&Rs, specifically Section 3.7 that the court inquired of, and 33.1807, there are not two liens created by virtue of the pre-existing CC&Rs that were, of course, recorded prior to the adoption of the Planned Community Act. What
There are just alternative ways to enforce that lien.
And the CCRs, since they predated the Planned Community Act, set forth procedures necessary to enforce basically the contractual rights between the parties, and it's acknowledged by the association as well as ourselves that the CCRs constitute a contract between the parties. Subsequent to that, when the legislature adopted the Planned Community Act, they added provisions that basically overlaid the application of then existing CCRs that were out there.
Do you agree with counsel that they can be read together, there's no conflict between the CC&Rs and the statute?
I agree that, as we briefed in our supplemental, Your Honor, that 1807 can be read and must be read together with the CC&Rs, but it doesn't create two separate liens. As Judge Howe indicated, there is only one lien. How you foreclose on it or enforce it has different procedural requirements under the CCRs and under 1807.
With that in mind, can CC&Rs, this is the broader legal question, can CC&Rs give additional protections that a statute may not require to its homeowners?
Absolutely, and that's and to the extent that the CCRs by contract provide greater rights that must be complied with before the homeowners association enforces its claim for non-payment, irrespective of whether it's under the CCRs or under the statute, which are just the remedies, actually, not the conditions preceding to the opportunity to enforce those.
And let me, if I may, one last question on that line. Is it possible for a homeowners association member, even if they're being pursued under 33.1807, to expect the relevant provisions that are not in conflict, we've already said that, of the CCRs, in regard to these types of events concerning the notice? In other words, we're pursuing a statutory provision, and in my very poorly presented theory here, is it possible to take the statutory provision and say, but the CC&Rs in this homeowners association allow one greater protection, which is the right to expect notice?
Absolutely. That'd be no different than the mortgage foreclosure statute or the deed of trust statute, foreclosure statutes that say that these are the procedural processes that you must follow to foreclose on that security interest. But it doesn't say that the minimum set forth in the statutes somehow subvert or avoid conditions that might be in the promissory note, the evidence of indebtedness, that might actually afford greater protections to that borrower under the circumstances. And that's the same way under the contractual provisions of the CCR.
So you do say they conflict. So if the CC&Rs provide greater protections and the statute doesn't provide those protections, there's a conflict between the two.
Well, the greater protections within the CCR still exist. The language in 1807A doesn't indicate any intention by the legislature to override the additional protections contained in the CCRs, and both parties have briefed other places within the Planned Community Act.
Walk through that briefly, because the statute says nothing else need be filed, right?
1807 says correct for priority purposes. That's what 1807E talks about.
Perfect this lien, nothing else is required to be filed. I'm sorry.
For assessments.
Right.
And then if you look at the second sentence of 1807E, it says that that's where you find that nothing else needs to be filed, but it only says for assessments. It doesn't say for attorney's fees. And in this case, the facts as set forth in the record, there were no assessments due after the bankruptcy. There was only attorney's fees that were incurred by the association in attempting to
After the bankruptcy.
After the filing of it, yes. And the notice that council has added by reference in their supplemental, to the extent it was in fact recorded in 2012, not within the record as we've already disclosed, predated the of the bankruptcy, which then discharged the any alleged obligations by Ms. Allen to the homeowners association.
Help me with that, because in my reading of this, it seems like the Superior Court believed that regardless of whether this had been perfected or not, it was discharged via the bankruptcy. And the case law that I'm reading seems to kind of cast some doubt upon that issue. So we got a separate issue of whether they met the requirements under the CC&Rs or the statute and all that controls, so whether this was a valid lien or not. But if it was a valid lien, didn't the Superior Court err in finding that it had been avoided by the bankruptcy? Not as to your client, but as to the property itself.
Well, the trial court found that the bankruptcy discharge eliminated all obligation by Ms. Allen for the payment of whatever was then due.
I don't think anyone's disputing that.
The issue as to whether the purported lien, and there is an issue as if it wasn't properly perfected, it was not a then existing lien and therefore would never have even purportedly been treated as a secured lien within the bankruptcy. And there's no question that unsecured creditors are discharged from all opportunity to pursue any alleged deficiency. As we supplemented in our brief, it's clear that from the trustees' reports in the bankruptcy that the association was treated as an unsecured creditor as a result of it showed an unsecured creditor status, showed that it was allowed unsecured claim, and that they made a payment thereon. And that was...
And it was unsecured because it didn't follow all the procedures of the 16 hours?
There was no, so far as I'm aware, Your Honor, there was no determination within the bankruptcy court as to whether the homeowner association had followed all of its conditions preceding to perfect its lien, but
under the CC&Rs.
Under the CC&Rs, the facts are clear that they failed to do so. There's no dispute by the association that they didn't do the 10-day written notice to Ms. Allen, and that they didn't record in October, or well, actually they started the second Justice Court action in July of 2013. They started this matter in 2015. Neither case did they produce for the record any 10-day written notice as required under the CCRs, nor did they produce any evidence that they recorded the notice of claim that is also set forth under 3.7 sub A. So
I have a question that pertains to something that you said earlier. I take it that a party can, parties can contract in such a way that they're giving more protection than would statutorily otherwise be authorized.
Yes. That frequently happens.
But that assumes, okay, here's what the statutory structure is. We're going to we're going to contract around that to fit our needs. That's not what happened here, because the CCNRs were negotiated and entered into in 1986. The code, if we're talking about, wasn't enacted until 1996. So it seems odd to me to say that the parties contracted the way they did because they wanted different rights than what the legislature provided 10 years later.
Well, certainly, given that the CCRs predated the statute, the issue of did they negotiate or contract around the statute, of course not. But that doesn't mean that the greater protections and benefits under the terms of the contract were somehow avoided by the adoption of 1807. And in fact, to the extent that you look at 1807, it actually really just talks about the remedy for when and if there's a existing delinquency in the assessments.
And it talks about creating a lien.
It says you have a lien, but that's, in essence, that's no different than what has already been brought up, in that the CCRs also said this will create a lien if to the extent you do the following things.
But and did the CCNRs say this is the only procedure that the AQA can use to enforce its lien, regardless of any future legislation that might give an AQA different or greater rights? I assume it didn't say that.
No, the CCR section 3.7a, I believe it is, Your Honor, says that it has basically two remedies. The association has two remedies: can pursue personal obligation and or foreclose. And it says as otherwise allowed by law.
So if the legislature in 1996 says AQAs were adopting this new code, you have an alternative way of enforcing your lien. That's not, an AQA wouldn't be precluded under the CCNRs from availing itself of that new additional right that was added later.
Although that would seem incongruent with the legislature's intent generally to adopt an act that was applicable to all planned communities, and that was so stated in 1801 of the Act. And by allowing two different, in theory, a statutory lien and a contract lien, when in fact the concept is that you have a potentially secured interest for an unpaid assessment, and depending upon the definitions of what assessment includes, whether that includes attorney's fees or not.
Well, but so that seems to go against you then. If we have an interest in uniformity and applying to all AQAs across the state, then it seems to me that the statutory procedure for enforcing your lien would take precedence over any procedure identified in any CCNRs, and that, in our research, when this issue has come up in other states, it indicates that that we look to the statute and not to the individual CCNRs.
To the extent that the statute doesn't subvert substantive rights, and I do submit that the condition precedent requirements under the CCRs are substantive rights relative to the homeowner.
So the legislature cannot, on its own, give an additional method of enforcing the lien. Is that what you're saying?
Well, the legislature can't take away substantive rights that have been on an antecedent contract.
But they can add something if they choose.
They can, of course, the legislature can increase the burden, or they can add benefits. Absolutely. They just can't.
That would presume it's a one-way. I mean, there's two parties to this contract, so they.
Yes, Your Honor.
How could they add burdens on the HOA if they couldn't take away burdens from the homeowner?
Well, I didn't mean to misspeak in that regard, Your Honor. I'm not saying that by adding additional benefits to one, if it changed the substantive rights of the other party, then that would be equally prohibited under the contract clauses of the Arizona Constitution and the U.S. Constitution.
Well, let's touch that for a second, because the rights, presuming we're talking about assessments after the date of the enactment of the Planned Communities Act, that's a whole new playing field. So it doesn't upset any existing contractual relationships. The assessments that come due going forward aren't necessarily altered. I mean, are under a different legal regime than the ones before that. A contract, let me rephrase what I'm saying, sorry. A contract clause type analysis wouldn't apply to the new debts incurred afterwards, after the enactment of the Planned Communities Act.
Well, going forward, to the extent that the court construed 1807 to reduce or take away requirements in the contract, yes, even going forward, you can't prospectively override substantive rights. You can prospectively change procedure and or remedies.
That's all they did, was change the procedure.
Well, I would submit that giving the notice and advising
They
the homeowner.
substituted a different notice provision for the one that was contained in the CC&Rs.
Without a provision in I that says notwithstanding anything in the CCRs. 1807 sub I, which is the section that requires the association to theoretically, truthfully respond to a query in a certain amount of time to a homeowner, among others.
But you didn't assert that defense below.
We asserted that they respond upon request of the balance due, that the association represented that there was nothing due, which would be under a waiver theory and a failure to comply with the statute.
Counsel,
It's the same issue.
Let me ask you a question. Is it possible to comply entirely with 33-1807, not claim a superior right under the CC&Rs, not to limit in any fashion the language of 33-1807? Is it possible to completely comply with 33-1807 and also possibly meet the requirements of a mandate of the CC&Rs? A notice provision, for instance. Do you understand what I'm asking?
I believe I do, Your Honor. Yes, you can certainly, if you were seeking to foreclose the association lien by judicial foreclosure, which is the reference in 1807A, you would still need to comply with the conditions precedent within the CCRs, the notice and the recording. After you had
Is that a contracted for benefit when they purchase their property, when they enter the HOA?
Well, it existed at the time they bought it, the property, so of course it's presumed that it was contracted. Obviously, my client didn't sit down and negotiate with the association for specific terms within the CCRs.
But if they read their CC&Rs, they understood that was something that would be available to them.
Correct, and to their benefit. And obviously, this would have addressed her very issue that when she came out of bankruptcy and said, "How much do you owe? Because I don't want to be in default anymore." And they send her a response saying, "You don't owe us anything. In fact, you have a $120 credit under 1807 sub I and under the CC&Rs 3.7C, both would have confirmed that she owed them nothing. And therefore, if she owed them nothing, if there's no delinquent assessments due, they can't begin the foreclosure. And that was one of the predicate findings of the trial court, that the association failed to meet its burden because they couldn't prove any existing delinquencies in face of the fact that they responded back saying, "You don't owe us anything." And that would have been required under the CCRs 3.7 or 1807 sub I. Based upon what we've submitted to the court, we believe that the trial court's decision ultimately dismissing the association's claims was warranted, and we urge the court to affirm that decision. Thank you, Your Honor.
Thank you,
Thank you.
Counsel. Counsel, you have been at 52.
I have just 4 quick points. There was a question about what happens to the judgment creditor's lien after bankruptcy. Is it discharged? The United States Supreme Court decided this in Johnson versus Home State Bank, where it specifically said Justice Marshall was the one writing the opinion. Although a creditor's right to pursue a collection on the note might be discharged under bankruptcy, and that's an in personam action against the debtor, the right to foreclose on the collateral is not extinguished. It survives the bankruptcy because it is an in rem right against the property. And so because it's an in rem right, it's not considered a personal liability of the debtor, which is what 11 U.S.C. 524A2 enjoins. Only actions to collect the personal liability of the debtor. I cited a case in my brief. It's In re Jackson. It's a Sixth Circuit bankruptcy appellate opinion, 554 BR 156. It's the only case that's been cited in the briefs that actually has to do with an HOA who was trying to foreclose on a debtor who had filed for bankruptcy. And the court in that instance specifically finds that the lien survived the bankruptcy and that the value of the lien could include both pre-petition and post-petition amounts. And in fact, they eloquently stated, foreclosure does not distinguish between pre- and post-petition amounts. With an in rem action, the creditor can enforce its lien as to all amounts that are owed. And that goes also to the waiver argument.
But you proceeded under the statutory lien theory, and the statutory lien theory under 1807I, I believe, says if you don't respond within 10 days and give them this notice, then you can't pursue that remedy anymore. It says it's foreclosed. And the court didn't say this artfully below, but they found, or they asserted the defense of waiver, which sounds to me kind of like an 1807I argument, and the court found that you guys were precluded from pursuing this. So tell me how I don't affirm on that basis.
The trial court never made a specific finding as to waiver. The findings were about the bankruptcy injunction and res judicata. There was no specific ruling or finding that specifically stated that the association intentionally relinquished its rights or that Section 1807I.
But you keep saying intentionally relinquish your rights. Whether it's intentional or not, I don't care. But 1807I says if you don't comply with this, you lose that right.
Right, and that was never a finding of the trial court. And because it wasn't specifically found in the trial court's ruling.
Your argument in response is we couldn't because of the Bankruptcy Act, but you don't pretend for a second you couldn't have said, personally, you're free and clear in your little notice, but please be aware we still have this lien and this amount on you, see 1807I.
Yeah, but 1807I doesn't require the association to describe whatever lien rights it has and what value that the association.
They have to tell them the amount.
It just has to state what the amount of assessments that are currently due. And
Even though you already told them there are none. This is what it just boggles my mind about this. We're telling you there's none, but you can't rely on us for that. You have to come in and individually ask us. Doesn't that seem like a little bridge too far?
well, so the 1807I, you have to provide a notice of what assessments are currently due. And all that the association could do under the bankruptcy discharge injunction was say, these are what's due post-petition. It's not allowed to say, you also have to pay all these other assessments because that would be considered a personal liability of the debtor. You can't collect on that from her pocket.
No, that's what I was saying earlier. You could have said, personally, you don't owe anything. However, we have an existing lien, which what 1807I says you have to tell them how much that lien is on the property. You could have done that, and that would not have violated the bankruptcy discharge.
Well, 1807I doesn't state that you have to assert that you have a lien and what you believe that the value of that lien
To
is.
tell them how much the lien is.
It just states that you have to tell them what our unpaid assessments then due. It doesn't say that you have to assert that you have a lien and that value is X.
And your argument is because you're not going after assessments, you're going after fees that doesn't apply then?
We're arguing that because we're pursuing our lien right
Under which procedure?
under either procedure, under the contract or the statute, that we're allowed to foreclose on the lien and then prove to the court what the value of that lien is. And that would be for the amounts that were due pre-petition, that she's discharged from having to pay out of her own pocketbook, and for any amounts that were due post-petition.
Thank you, Counsel. Your time is up. We appreciated your arguments today. We will take this matter under advisement and will issue a decision in due course. We stand adjourned. Thank you.